I want to welcome you to Friday morning rehab, and we're going to get started quick because we're a little bit behind schedule already. So I think we're missing one member. We're going to, clerk, go ahead and call the roll.
You have a quorum, Mr. Chair.
Thank you, Madam Clerk. Okay, so the plan is to take up the social services bill this week, and I think I put out the last meeting that we're going to try to do ABC bills next week. So for those members who have ABC bills, make sure you have your witnesses here next week for that. The first thing I'm going to do is take care of some bills that, at the request of the patron, are going to be struck. First up in the queue is Senate Bill 704 by Senator Chase. She's requested that bill be struck. All right, I have a motion. It's been seconded that Senate Bill 704 be stricken by the patron. Clerk, can we call the roll?
Ayes 13, no 0.
Ayes 13, no 0. Second bill we have is a bill that came out of here last week by Senator Edwards. It's Senate Bill 296. He's asked that that bill be reconsidered, and then he would like to strike his bill. Senator Cosgrove, I think you were on the yeas. So, second. All right. So the bill 296 is before us for reconsideration. All those in favor of reconsideration, that bill, vote aye. All those opposed, nay. All right, the bill's back before us. Senator Edwards, do you want to speak to the bill? You just want to go ahead?
I'd like for it to be stricken. Thank you.
Okay. All right, there's a motion to strike. It's been seconded. All those in favor of striking the bill, vote aye. Okay, Senator Edwards, thank you. Is Senator Carrico here?
Ayes 13, no 0.
Ayes 13, no 0. Okay, Senator Carrico's not here. Is Serval here? Senator Serval, you want to go ahead and we'll take care of 93 real quick. He wants to strike that bill, but wants just about. Okay, all right, as you were then. Okay, we're not going to do that. All right, we have Senator Chase. You are up.
Thank you, Mr. Chairman and members of the committee. We're going to take up, did you want to take up Senate Bill 716 first?
Whatever your liking is.
Okay. Senate Bill 716 pertains to the Department of State Police, and this is a recommendation for options to expedite the process of background checks. The Virginia State Police headquarters is right on the edge of my district, and how this came up was we had some of the private schools coming to us and identifying that they had a problem. And the problem is that every time they hire a teacher, they do background checks. And when they have the public schools come in, theirs go to the very bottom, and as a result, it can take up to a year for some of their teachers to get their background checks, and it's caused a real problem and a backlog. We also know that there's a teacher shortage in Virginia, and it's just the whole background check and background check process in general is just really clogged up. And so I visited the facility to see if I could get an idea if there was some automation that could be done on the front end, because it is a very manual process, especially with the criminal background checks where you have the fingerprinting. So I spent some time with Colonel Flaherty and the good folks at Virginia State Police, and we came to two options. The first one is a request for information. It's going to be a study. The first one is for $150,000. I put in a budget amendment for that. And this is a study to figure out, what exactly is the problem here? Could we put some more automation in, just kind of really get a good idea of what the problem is? That's my first bill. And it states that the Department of State Police shall identify, analyze, and recommend options to expedite and improve the efficiency of its process for performing requested background checks. Now, this brings me to my amendment, because I want to strike the next line, and if I can have that substitute passed out, that would be great. It says such options may include a process through which persons are given an option to pay a higher fee for the performance of background checks in exchange for expedited service. I'd like to take that out because there are members in my caucus that will vote against higher fees, so I would like to strike that. Thank you. So other than that, that's really the only change to that bill.
So you have some amendments?
There is an amendment that should be being passed out.
Mr. Chair, we don't have a hard copy of it, but I did draw it up with our legislative assistant before. So it is going to be on line 13, after checks, period, strike. Such options may include a process through which persons are given an option to pay a higher fee for the performance of background checks in exchange for expedited service, period.
So we're just striking the language altogether. Okay. So the amendments before us has been moved and seconded. All those in favor say aye. Aye. Any opposed? All right, that amendment's been approved.
Okay, great. Thank you very much. So I would like to let you know that DSS is fine with this bill and the budget amendment, the budget language. Also, the Virginia State Police, I have Wayne Huggins here to express support of the bill as well, if you'd like to hear from him. I also just want to I think it's appropriate at this point to talk a little bit about my other bill.
Let's get through this bill before we talk about your other bill. Mr. Huggins, would you like to come up and speak on behalf of the state police?
Thank you, Mr. Chairman. Wayne Huggins, State Police Association. I'm not speaking on behalf of the state police. Dan Wilson will speak on behalf of the department. I'm speaking on behalf of the State Police Association. We very much support this. No service that we provide to the citizens of the Commonwealth is perhaps more important to them than background checks. Whether we're talking about teachers, firearms transactions, adoptions, employment issues, whatever it may be. And they deserve to get these checks done as quickly and efficiently as possible. We very much appreciate Senator Chase's interest in this and would very much appreciate your support to help us make this a better process. Thank you.
Thank you, sir. Yes, sir.
Mr. Chairman, members of the committee, Dan Wilson of the State Police, we support this. We appreciate the senator bringing it for us, and I echo Colonel Huggins' sentiments. This is a struggle that our folks are really trying to get our arms around. It's just a matter of numbers.
Can I ask you a quick question? How many people are running background checks right now? And are all those people sworn law enforcement, or some of them civilian with clearances?
Yes, sir. No, there's a significant number of folks, I don't have the exact number, that are running background checks. Most are civilians and some are sworn. But again, the numbers increase every year, so that's really what we're trying to get our arms around.
Okay, thank you.
Thank you.
If you're in support, come on up. Just tell us who you are and.
Good morning, Mr. Chairman, members of the committee. Grace Creasy. I am the Executive Director of the Virginia Council for Private Education, and we are thankful to Senator Chase for bringing this bill. We support the bill fully. Thank you.
Good morning, Mr. Chairman, members of the committee. Matthew Stanley, representing the Virginia Association of Independent Specialized Education Facilities and the Virginia Coalition of Private Provider Associations. This is not an issue that just affects private schools. It affects many different types of professions within the Commonwealth that require background checks. And within all those professions, we are seeing serious delays. Average turnaround time that we tell our members to expect is up to 2 months, which is somewhat unacceptable for business operations and continuity. So we very much appreciate the Senator's efforts to try and find ways for the Commonwealth to expedite this process. Thank you.
Thank you.
Good morning, Mr. Chairman. Matt Benedetti, representing the Virginia Child Care Association. We're the private for-profit providers of child care, and we support the bill.
Senator Chase, any members have a question for Senator Chase?
Yes, Mr. Chairman.
Go ahead, Senator Sproul.
Thank you. I was asked a while ago, I'm trying to find out why they have to go through this based on in a public school right now, when they do interviews for who they want to hire for teachers. They get it done. I don't know what is the process, but they get it done right away. So I'm trying to find out why you got to spend money. What's the difference between the private school and the public school as far as background check, as far as hiring teachers? What I'm afraid of, that you go to finance, when you say finance and appropriation, that scares me. And I want this thing to pass.
Right.
So I'm trying to find out why you got to go through this process when the public school do interviews for teachers. I don't know what they're doing, but they hire them right away.
Sure, that's a great question, and that is exactly what's happening. Is the private schools are being put at the bottom. The public schools take priority over the private schools. So anytime the public school has a background check, it goes right through. but the public school ones get put on the bottom.
Must-
And I also will say that I'm getting insurance brokers calling. They have people they want to hire that need background checks who are in my industry, in the finance industry, and are trying to get a background check for the financial services industry, and they're also at the bottom of that pile too.
Mr. Chairman, second question.
Senator Broll.
So the finance part of it, so if we don't get the finance part of it, would this bill be jeopardized if it goes to the finance? If we don't get that money, would this be in trouble?
Yes,
Lord Jesus.
that's
Thank
what
you
I
so
said.
much. Thank you.
Thanks, good
Thank you, Senator
questions.
Broll. Anyone else have a question for Senator
Mr.
Favola?
Chairman. Thank you, Mr. Chairman. A question for the patron. Is part of the reason that we're having such a delay related to resources? I mean, I understand this bill merely asks them to evaluate the process and to come up with something more efficient. I would expect that maybe next year you'll be back asking for some resources, because that, at the end of the day, will probably be an important element to correcting this. Is that fair?
You know what? You are so intuitive, Senator Favola.
Oh, that was
Because
a big
that-
leap. I thank you
that
for
is
that.
that is going to be my second bill that I mentioned to Senator Reeves. I've already got the RFP for the amount. So I have a Plan A and a Plan B course of action that we can resolve today.
Okay, if no one else wishes to speak, the bill's before us.
Mr. Chairman, I move to report and we refer to finance.
Okay, it's been moved and seconded to report the bill and refer it to finance. Committee will vote.
Ayes 13, no zero.
13-0. All right, next bill, Senator Chase.
All right, this is Senate Bill 702, licensure exemptions, private school programs and exemptions.
702.
Okay. All right, so certified preschool licensure exemption technical fix. The certified preschool exemption was amended by the 2017 General Assembly and House Bill 1837. The resulting regulation and statutory changes were this. It allows children to attend preschool programs for 5 hours with a maximum of 4 hours of instruction, allows the certified preschool program to include 3 and 4-year-old children, clarifies the qualifying preschool programs or instructional are not considered child care, permits the Commissioner of Social Services to inspect certified preschool programs to ensure compliance with applicable requirements. The CP exemption was previously being used for a state-recognized accredited school that operates a full-day academic JK program for 4 and 5-year-olds, but the program was notified by DSS that they are no longer eligible for the exemption, and they would have to either become licensed as a child care center or transition to a 5-hour per day program under the new provisions of the CP exemption. This was caused by the consolidation of subsections with Virginia Code 63.21717 and was not identified as a consequence of the 2017 legislation by DSS, DLS, VCPE, or any legislator. VCPE wishes to correct the oversight and restore the ability of full-day academic JK programs serving no child younger than 4 to continue to operate with the certified preschool exemption as they have in the past. And HB 867, which Delegate Orrock is carrying, and Senate Bill 702 will remedy the situation. And I think VCPE is here to express their concerns.
Thank you,
as well.
Senator Chase. To the members, this original bill flew out of here after lots of subcommittee hearings. In fact, I chaired the subcommittee on daycare and Senator Hinger's bill, working with Delegate Orrock. This was one of the unintended consequences that they're trying to fix at this point, that as a result of that big omnibus sweep on child daycare. So this just fixes something that was overlooked. I want to say it's more technical than it is actual substantive in nature, but if you'd like to speak to it, step on up, sir.
Thank you, Mr. Chairman. Matthew Stanley, representing Virginia Council for Private Education. Again, this is just restoring what these certified preschool programs were able to do prior to July 1st of 2017. The legislation last year consolidated a couple code sections, and we did not realize this consequence, so we appreciate your assistance in fixing this.
Absolutely. Anyone have a question for Senator Chase on this one? You've all heard the bill. All right, been moved and seconded to report.
Mr. Chairman,
Where am I looking?
sorry. Can we hear from Department of Social Services on, if they're here in the room, on what the issue is with the denial and how this came about?
Dr. Chairman, just on.
Good morning.
Hi, I'm Charlene Vincent, and I'm the Director of Licensing for Children's Programs. I believe last year there was a bill, and we took away some of the provisions that, for an exemption, thinking no one used that exemption, and then lo and behold, we were told later after the bill had passed that the exemptions, these exemptions were used by 2 or 3 programs, and so this language puts the exemption back in. Thank you. But we have no position.
Thank you, ma'am. Senator McCluck, you good? All right. So we have Senate Bill 702. I think it was moved and seconded before us. Committee will vote.
Ayes 14, no 0.
Ayes 14, no 0. So, okay, your bill passes on that one. Your next one, Senator Chase?
I think, is that everything? We struck 704, I did 702, 716, and that should be it.
That's it? Okay, thank you so
very
much.
much.
Senator Donovan. Actually, Senator Donovan, can I put you on standby? I see Senator Carrico there. He has a witness that is driven all the way from Southwest, and I think his bill will be fairly quick, and he's got something to do. Senator Carrico?
Thank you, Mr. Chairman, and thank you for, and I apologize, but I do have a Reverend Mike Sage, who this bill affects, here today. He drove up from Southwest Virginia, and I just want to give him an opportunity to speak. But simply what this bill is attempting to do.
It's members, it's Senate Bill 506. My apologies.
Under the religious exemption that I think hearing from the licensure people today, there's 5 organizations under this. Reverend Sage is here today to speak to this, but Freedom Tabernacle Church has been servicing and ministering to children for over 40 years. They have what's known as Camp Freedom there on their premises, that they have run programs in the winter, summer, and fall where children are able to come and do recreations, academics, and special projects. They have big gardening facilities there for them to be able to learn a lot of agricultural things. And their ministry has grown tremendously. And I have a letter here from the Circuit Court Clerk, John Graham, who is also in support of this, if I can get this young man to pass those out. But what this legislation is in an attempt to do is they want to grow, and they want to invest, and they want to build on their premises a facility that will house these individuals, these children that have problems in the community, and let them be able to stay there and be able to be housed there. But they want to still be able to minister to them. So they feel like that because they've been in existence since 1975, and that they've run a facility, they just never built a big enough facility until now to be able to house them 24/7. And they feel like that they should be grandfathered like the other 5 facilities are in the state of Virginia under the religious exemption from the licensure process. And that being said, that gives you the genesis of why the bill's here. But I want Mike to speak to you and to let you know, because this church has done a tremendous, not just in my area, but in Senator Chafin's area. Mike's well-renowned all across Southwest Virginia as a minister and as someone compassionate and a heart for kids to try to steer them in the right direction. So, Mike, if you'll come on up here just a moment.
Good morning, Pastor.
Well, thank you, Senator Carrico. Thank you, Chairman, and all the members. I appreciate the privilege to stand here. I will be brief, I promise you. We have a foster care home on our property, and of course, been working with a lot of situations over the past 40 years with DSS and child
Mr. Chairman,
services.
I'm sorry, can I interrupt
Yes.
just for a second?
Yes.
Pretend like you're giving a big fiery sermon, because I can't hear you very well.
I'm trying to be reserved because you get me started, it's hard to get stopped. And I'm trying my best to be brief because, we could talk a lot and say a lot of things. Our corner of the state, like all across the country, we deal with domestic problems a lot, and the opioids, drugs, the family unit, and we're right on the front lines basically every day. We have a shelter facility there on the grounds that Smith County Sheriff's Department will readily tell you we're the only shelter facility for homeless and troubled people in the area. Now, as far as child care with the foster care, we got a lot of foster parents that we know really well. And so many of them want the babies and the little ones. And what I personally run into for years now, when the children get 12, 13, 14, go from concrete thinking to abstract thinking, and they get out and for basically family reasons, they're falling through the cracks, and I go down to Southwestern Regional Jail, look through the plexiglass, get on the phone with a child it's heart-wrenching to see that they ended up that way. And, you can't save them all, but I think if we had a residential facility to where we can offer more permanency to some of the older children. And then I was made aware yesterday by one of the child care workers that there is a law that I was totally unfamiliar with, to where now the workers don't have a local resource in Southwest Virginia to put some of these troubled children. And of course, domestic relations court, juvenile court. And say a child hypothetically ends up in Northern Virginia, and then their parents, in the attempt to try to salvage the family unit, need to make visits to that child. They're unable to do that. They don't have enough money to drive to Roanoke, much less Winchester or something. So all our heart is to try to help these children. And personally speaking now, I don't have any problems, never have, with oversight, licensure. I think we have a record of safety. You can see the reference letter there from Mr. John Graham, who is our local clerk of the circuit court. We minister to many, many children every year. Winter camps, summer camps, periodic theme camps. We've got 55 acres. We've got all kinds of facilities. But the reason I'm here today is we've got the resources to start building a brand new facility that would be a great resource to our part of the country, for our part of the state. But to be quite honest with you, we don't want to proceed with building a new facility if the Commonwealth's not going to give us a licensure to do so. So that's why I'm here. I appreciate Senator Carrico's help. I know you all don't know me. I don't know you. But trust me and believe me when I say we are more than willing to work with a licensure or the state child care people. We don't have a problem with that. We're not wanting to be a maverick or run around and do our own thing. Just collectively be an extension of the good work that's being done by a lot of people across the state. But I think if you would ask our local judge, Florence Powell, at the Juvenile Domestic Relations Court, our sheriff, anybody in DSS down in our part of the country, I don't think they would have a problem with us trying to proceed with this. So hopefully you'll be sympathetic and understanding and not just immediately turn us down, but at least consider a discussion. Thank you.
Thank you very much. Anybody have any questions?
I have, Mr. Chairman.
Senator Spruill first.
Reverend,
Yes.
do you have the staff to, you can build a home where the kids can live there? And I know when you have these type of homes that we're not talking about church folk now, Do you have the kind of staff to do whatever it is to do to a living?
Our staff would be educated with proper education and could be working in any facility.
So you could take, I'm sorry, Mr. Chairman.
Senator Sproul.
So the question that you're saying the kids in the areas who having trouble could come to this foster home? This is for all kids or just for church members?
Oh,
kids?
this is for any and all. We have a record of that. We reach out
Third
there.
question, Mr. Chairman.
Go ahead, Senator
So do your church have the funds to build what you want to do?
We're going to raise them. And we're not in any way soliciting any type of state funding. We'll fund it ourselves. We've got some, folks who have given some tremendous building materials. We're at the ready we have already a house on the property.
Yes, sir.
Where we have foster care in that. Now, short term, if we could proceed, we're able to do it.
Last
quick.
question.
Senator Sproul.
But to expand, that's going to take us, a year or two.
Last question, Reverend. Would this be a foster home or what would it be?
We would like a more permanent residential facility for these children, especially if they're 13, 14 years old, could,
And they leave when they finish their leave?
We would like to see them on through, and as a matter of fact, we help when they get 18 and they're out, we've been trying to help those age children. Well, I call them children; they're young adults.
Yes,
but there's a real need when a child turns 18 to 20 to 22.
Thank you, sir. Thank you.
Thanks, Senator Sproul. Before we take up another member's questions, I'd like to hear from DSS if there's any extenuating circumstances or if you guys have any heartburn with it, or does it expand your challenges, or?
I'm Charlene Vincent again. I'm the Director of Licensing for Children's Programs, and I'm here to say the administration opposes this bill, and as does DSS. Children's residential facilities are licensed under standards for children's residential facilities. There are 42 operating across the state. Many are religiously affiliated. The standards that in this bill are asking to come under were frozen in time in 1987. They have not been updated in 30 years. Therefore, they lack the protections that have come about as child welfare practice has changed and best practices have changed. There's nothing about emergency preparedness or admissions processes or staff training has evolved and things like that. We do not feel that it's fair that one facility is singled out to be exempted when all the other ones have to comply. You can do wonderful and good things even when you're complying with these standards, and we certainly wouldn't want to get in the way of all the good things that children's residential facilities do accomplish. But we do think they need to come under the children's residential facility standards that have been updated and contain the best practices that are in effect today. And again, the CCI standards were frozen in time in 1987.
Thank you, ma'am. Senator Carrico.
I just want to speak to that. You heard Brother Mike talk about, this is an advancing church. They just built a new church. I mean, it's huge. They do everything to today's standard. They don't have any problem with that. But in all fairness, and if the licensure agency will tell you, there are still a few churches that are under the 1987 rules, the exemption. This facility has been in place since 1975, and all we're asking is that they have the exemption as these other churches have. Most of the area facilities, I just was talking to the lady today about Joy Ranch, was one that's been in my area for years. They were under the exemption, but then they transitioned under the licensure process. All we're asking is if they are given the exemption, to let them know that they can build this facility without any problems. And I'm sure that you've heard the man's heart. There's no way that they're not going to proceed, even if we do this today. They're still wanting to do this. If they have to go under the licensure process, it's just going to be harder for them and delay it even longer for them to do it.
Gotcha, thank you. Senator McPike, did you have a question?
Yeah, to the Reverend, first off, I appreciate the work you're doing. I have several facilities in my district that are like this and provide foster outreach, other services to the community. I've heard and understand you've built some new facilities. You had to comply with modern building code in that process, right?
Certainly.
So is there a burden to comply with the licensure requirements associated with this? Because I have a little pause at the consideration of adding new facilities under this provision, much like I'd have the same cause for concern of, say, exempting buildings from an older building code, for instance, from 1978. Lots of things have been updated since then for very good reason, because there's been examples over the years of why things have been improved. You spoke to the fact that you're willing to work with licensures and you've looked at some of the provisions. Is there some specific area that you can't comply with our current code or statute in this regard?
No, sir. Believe me, we're well versed in building codes and requirements like that.
But in regards to this licensure?
I would have no problem with that.
Okay.
And I know that's probably sounding contradictory. We're asking for this exemption, but, your all's oversight will be right there, So if I've seemed confused on that or contradictory, I apologize.
Thank you, Mr. Chairman. I appreciate the reverence.
Thank you.
Senator Mason.
Thank you, Reverend, for the important work that you do. I
Well,
mean,
you're
I think
welcome.
everybody in this room appreciates all that you're doing to help people, and thank you. The question may be for DSS, because what I don't understand is what would you not have to do if we passed this that you would have to do if you went through the regular process? Is it money? Is it time? I know there are new standards. There got to be a lot of new standards, certainly. But do you know what additional, I guess you would consider, burdens would be put upon you if you went through
Well, just
the
like
normal
the
process?
building codes, the physical building, sure, it's more strenuous than yesterday, but I mean, progress is progress.
Yes, sir.
We do our best to comply, and we've got to. We wouldn't got a CO on the new facility.
Certainly.
And trust me, it's taken us 8 years to build this facility that we have. We go slow. We have a gymnasium, we have educational buildings, and we've did that through the years slowly. And it's like building this new facility. We're certainly aware that we're going to have to meet whatever state codes, building codes are in place. So we don't have so when you come down to licensure requirements, whatever, any of y'all's representatives, they know us now.
Yes, sir.
We have a wonderful relationship, with our local folks. I guess I've been so busy, this was brought on me yesterday, so I haven't really looked over all the proposals here on this bill, just to be frank and honest. I appreciate the attempt to, and hopefully we could be exempt from some things. Naturally, that'd be a little bit less on us, less strenuous financially and burdensomely. It's difficult today working with subcontractors, building buildings. I know all that. But as I said at the outset, whatever we've got to do, these children that I deal with every day, by the way, my wife's a school teacher in Smith County, has been for 30-some years. She recently retired. We work with all the principals, all the school. I was a Virginia school bus driver for 36 years. I affectionately call that my rolling orange laboratory for the ongoing studies of childhood and adolescent psychology and behavior. But anyhow, we're in the trenches with these kids. I got some ex-foster kids that come to church every
Pastor,
Sunday.
I don't mean to be
Now I'm
short and
rambling
cut you
on.
off,
I
but
warned
we
you.
got an hour and 10
I
bills
warned
to
you. I
go,
warned you.
so.
Don't get me started. I'll be right. I'm sorry. I apologize.
All right, Senator Favola, you had a
Okay.
question? I'll get her up just a second, real quick, and then we try to wrap this thing up. Put a bow
Well,
on it.
Mr. Chairman, my question actually was quite similar to what Senator Mason asked. I guess I would just ask the Department of Social Services to work with the applicant and to try to make the process as understandable and smooth as possible. I'm very uncomfortable granting the exception. I'm not very clear about what I would be be allowing the applicant to not provide, and that has me anxious. So I just think we should not pass this bill, but to direct the Department of Social Services to work with the applicant to make the process understandable and efficient and seamless.
Is that a question? Is that,
Well, I can make
wouldn't you
that-
agree or anything?
No,
I got it. I got it.
Yeah, would you agree with that, Mr. Chairman?
Yeah. Senator Chafin.
Thank you, Mr. Chairman. In the years that I've been here, a constant theme that we deal with is inadequate funding, lack of funding, the inability to meet the needs of youth, the needs for people that need emotional help, that need psychological help, that need help, people that fall through the cracks. The children, as Pastor Mike said, I mean, we have children that they get to a certain age and nobody wants them anymore. My law firm represents Department of Social Services, local departments. We understand that everybody wants the baby. Everybody wants the 2-year-old, the 3-year-old. And these children, these young adolescents need a home. They need love. They need encouragement. They need shelter. And we need to be finding a way to say yes to people that are willing to step up and put their resources to work for the Commonwealth and for the communities. We're not talking about some corporation here that's going to make a lot of money taking care of these youth. We're talking about people volunteering their time, working to put a roof over their head and to protect them from what they have been subjected to for years and years. And I don't know how anybody could say no to that. I just don't know how we could say no to that. So with that in mind and understanding that I think this is a very good bill and a very good effort by a community to meet its own needs, I move that we report the bill.
So it's been moved and seconded to report.
Mr. Chairman.
Senate Bill 506. Senator Hanger.
Mr. Chairman, I have some empathy for the situation. What I'm concerned about is this 1987 regulation. I think it may be more appropriate to kind of encourage the Department of Social Services to work with the good pastor here who's indicated a willingness to comply with everything. He just needs to move forward. He's going to do good things. So I think it would be more in order for us to continue the bill in this committee and perhaps ask DSS to give us a report on what's going on with some of these entities that were grandfathered in the 1987 ordinance and see if there is some latitude there. When we just do a blanket thing, there's so many of these institutions out there that are doing the very same thing that this good pastor wants to do, that are subject to all the licensure requirements, which now include fingerprint background checks and staffing ratios, all kinds of things that we probably shouldn't just say, well, you don't have to do any of that, because he's going to do it out of the goodness of his heart, but it would be probably unfair. But to continue it, then we can keep an eye on it over the next year.
We already require all of that.
Right, right. See, I don't think you have a problem. I really don't think you have a problem.
Can I just comment on that one statement? Just keep in mind, this church has been operating a facility since 1975. They just didn't house them overnight. So if they would have in 1975 housed them overnight, we wouldn't even be here because they would already be exempt from it.
Right. And if members will bring their attention, there are while minimum standards, there are standards set in place, if you read the entirety of the bill already, that it does have some of those protections that Senator Hanger is talking about, just not to the current form where we've loaded it up as we are today. So with that, Senator Cosgrove.
Yes, Mr. Chairman, I admonish everybody here to understand there are different parts of this state. We're not talking about an urban or even suburban area. I've been fortunate enough to visit Senator Carrico and actually stay overnight at his house. I actually sang at his church. It's a whole different world there than it is in Hampton Roads or Northern Virginia or Richmond. And I would say the pastor is here. He's been doing this for a long time. We're just looking for an overnight facility here. here's the deal. If we don't do it, there's nothing there. And we keep talking about the need to provide these services to these troubled kids. This is what this gentleman wants to do. And I know it's a little unusual, but we've carved out things in the past. And I hope that we'll vote to pass this bill. This is necessary. He is doing the work that we all want people like him to do. So God bless you, sir, and I hope this bill passes.
Thank you. We did have 3 children's services workers yesterday cross their fingers and say, I hope you can do and proceed.
So the committee has, not to interrupt you, Pastor, I'm going to get rolling. So the committee has the bill properly before us. The motion's been made. It's been seconded. We're going to vote on the clerk call the roll.
This is to continue, right?
No, this is to pass the bill. All right, so there's a substitute motion to pass by for the year. Does it have a second?
Second.
It's been seconded. All those in favor to pass it by for the year, vote aye. To continue it for the year. Pass by for the year, not pass by indefinitely. To continue it, vote aye. Those opposed, vote nay.
Ayes 7, nays 6.
So the bill will pass by for the year.
All right.
To be continued. It'll stay in the breast of the committee, Senator Carrico.
Thank you.
Pastor, I would ask you before you leave, if you could find some time to sit down with the Department of Social Services and maybe exchange numbers and find out, kind of get up to speed on what it's going to take to get there, and look forward to visiting with you at some point when I come down to see my good friend Bill Carrico.
Come on by anytime.
Thank you, Pastor.
Thank you.
Senator Donovan.
Good morning, Mr. Chairman, members of the committee.
morning.
This is my first time with you in rehab. And I have Senate Bill 636. You've actually already passed this bill through with Barbara Favola. There is an amendment from the Attorney General's office that I believe you have to conform it to hers. And just for an opportunity to talk about this important subject that obviously resonates in a bipartisan way, it really references what you were just talking about so heatedly, is that we have so many children in need, especially with the opiate crises. We've had an increase in children in foster care from around 2,000 to 5,000. And in some cases, we are not paying families in need that foster these children, and it's just not right. We also are 48th out of 50 for states of permanency, which means that we actually find a place for a child to grow up that's safe. And we need to do this and make sure that we give kids the opportunity to thrive despite the challenges their parents are having. So I would ask that you pass the bill and send it on to Finance, where we will find a way to put them together.
Senator Donovan, I'm understanding from my attorney that the line amendments are 6 line amendments, but we don't have those yet. Do you have them?
I'm sorry, I have just one line amendment, and I do have it, and I'm happy to share it, and we can fix it in Finance if need be.
You have it? Okay. So David, would that put us in with Senator Favola's bill, or will it still be different?
I believe that conforms it to mine, but I have to see the. We're going to check it.
Committee to stand at ease for a second. Okay, go ahead, Senator Donovan.
So, Mr. Chairman, in light of the fact these are additional amendments from DSS that I've not had the chance to look at, and they do reference some complex places in the code. If I may, if the committee would consider passing this bill and sending it on to Finance, we can reconcile them there.
Senator Favola.
I would move that we report the bill. And what's going on is that DSS is continually being informed and revised by their federal contact. What we're trying to do is draw down funds from a federal program, which is actually fairly prescriptive. And we periodically need to change our proposal that will one day hopefully become law to conform to federal requirements. So that may be what's going on.
Okay.
And I would ask that we.
Do any
pass-
members have a question for Senator Donovan? I see you have a long list of people who'd like to speak behind you, but I think we're probably in pretty good shape. Maybe they don't need to speak. Does anybody have a question? No? Okay, so the bill's before us to pass and re-refer to finance. That was Senator Favola's motion. Do I have a second on that? It's been moved and seconded that we pass Senate Bill 636 and re-refer it to finance. All those in favor vote aye. Those opposed, nay.
Ayes 14, no 0.
Thank you, Mr. Chairman.
Thank
members
you,
of the
Senator Donovan. Senator Dietz, you've been waiting patiently.
Thank you, Mr. Chairman. Mr. Chairman, members of the committee, I've got Senate Bill 682, and it's identical to a bill I introduced last year. And last year, this bill was wrapped into a larger bill that ran into some trouble in the House of Delegates, I think. But what this bill does, it exempts from licensure daycare programs offered by local school division and staffed by local school division employees and attended by preschool-age children who are enrolled in a program at the school from licensure. It's been requested by Charlottesville and Albemarle. I've got some line amendments to ensure that the kids we're talking about kids no younger than 4 years old who are part of the program that exists at the local school. And the reality is in some of these neighborhoods in Charlottesville and around Charlottesville, there's just no choice. The parents are at work these kids, the only opportunity they have for any supervision or for any activity is at the local school.
That's the bill. David, you want to read the line amendment?
Mr. Chair, there are 3 line amendments. The first is on line 65 after by, strike preschool-aged children or. Second line amendment is on line 65 after are, insert at least 4 years of age and are. The third line amendment is also on line 65 after public school, insert or a preschool program.
And those amendments, just to clarify, we're not talking here about 2- and 3-year-old kids who
Okay,
are.
let me get the amendments approved. We have amendment for it. It's been moved and seconded. All those in favor of the amendments, say aye.
Aye.
Any opposed? Okay, those amendments, so it's before us now, correct?
Yes, sir.
Okay. Anyone have any questions? Senator Favola.
Thank you, Mr. Chairman. I guess a question for the patron or maybe the Department of Social Services. What are we trading off when we're saying they would not be subject to any of the
Licensure?
state licensure requirements?
I think they've only been subject to licensure for the last couple of years, and the problem is that for many kids, at least in and around more urban parts of Albemarle County and Charlottesville and probably in other parts of Virginia, there's just nothing else for them to do.
I do understand that, but
Senator
I'm wondering, thank you, Mr. Chairman. I'm wondering what part of the state licensure requirement the schools would find difficult meeting.
And I don't know if anybody is here from Charlottesville today or Department of Social Services can address that.
Senator Deitch, are they going to be watched in school, on school property? And
Yeah.
these are teachers, correct? So they watch our kids all day long anyway.
Yeah.
They are public employee, they're public school employees, people that work at the school. So the school may have aides, not certified teachers, but they may have aides that help them with after-school programs or something.
So it's school within a school.
It's school within school. But
Gotcha.
It's on public school
simple.
property, public school employees. And more than that, it's a program.
So they're being governed by the school board and everybody else.
Absolutely.
I got it.
So there's some
Okay.
accountability.
Does that suffice, Senator Favola?
Well, yes, I do understand. I was just trying to really be very clear about what the state licensure requirements might be and what the school board's option might be. I'm more comfortable with this than I would be with just a flat-out exemption because the local school board is held accountable by the voters. There's some transparency. They do have, does the Department of Education have any, because this is preschool, so
And
DOE may not get involved, but they might.
Mr. Chair, Mr. Chair, members of the committee, Senator Favola, the school board in Charlottesville is the one that asked me for this in the first place, and the school board in Albemarle County said we want it too.
And this does apply.
Senator Fuller, can you please go through me? You're going to drive me crazy this year.
So sorry. Mr. Chairman, just a point of information, this does apply to the Commonwealth. It applies statewide.
Sure
It's
it
not
does.
a
Sure it does.
carve-out.
But, Mr. Chair, the language that we put in, the language in the amendments tightens it up, I think, so we're only talking about kids that are already at the school, 4-year-olds.
Shall I move
Thanks, Senator
approval?
Deeds. All right, so the bill's before us. Anybody else have any other questions? Senator Sproul?
Move approval.
All right, we have a motion to approve. It's been seconded. It's properly before us. Committee will vote. Mary Ann?
Ayes 14, no zero.
Ayes 14, no zeros. Senator Deeds, you're out of here.
Thank you very much.
Thank you, sir. Senator Marston?
Thank you, Mr. Chairman. Senate Bill 851.
Committee will bring its attention to 851.
Okay, thank you, Mr. Chairman. This legislation seeks to provide correctional officers with a similar procedure that other public safety officers have for when an allegation is made against a correctional officer or disciplinary actions for performance-based issues is being considered that could lead to dismissal, demotions, suspension, or transfer. And I do have a line amendment, something that I missed. And the line amendment would be on line 26, after correctional officer and before the colon, that it would say not in their first year of probationary employment. This was not meant to provide these rights to people in their first year of state employment. That's pretty traditional, and we missed that in the drafting of the bill, and I'd ask that that line amendment be offered. That would take 1,500 folks out of the bill
David, do you have
appropriately.
the line amendment, please? Okay. Give us a second. I think they're working on that, Senator Marston.
All right. I thought that might be the best place to put it.
Senator Deesdale.
Senator Morrison, you said on line 26,
I believe so, yes.
and then after which word?
After, after correctional officer. I didn't want to change the definition of correctional officer, but a correctional officer not in their first year of, their probationary first year of employment.
Okay, so it'd actually be on line 27 of the bill that's currently filed, right?
David, do you have it?
I might
Go
have a slightly different.
I think, Mr. Chair, I think the amendment would work as presented. So it would be on line 26, after correctional officer, insert, not in their first year of probationary employment.
Mr. Chairman, if I may, if you're
Senator Deesdale.
looking on the iPad, it would be line 25.
Yeah, it's weird.
So this is, yeah, the PDF version's a little different from what you have. So I was just trying to go through it and was very confused because it really didn't make sense in the other spot, but this makes a lot more sense, and it's just a format issue with what we have and what you have on paper.
David, you got that script?
Mr. Chair, just so there's no confusion, the amendment will be at the end of the first sentence in subsection A under section 9.1-509. after correctional officer before the colon. Insert not in their first year of probationary employment.
Okay. So we have the amendment before us. It's been moved and seconded to approve that. All those in favor say aye.
Aye.
Any opposed? Okay, now it's properly before us.
Mr. Chair.
Thank you. Thank you, Mr. Chairman. When a correctional officer takes their post, they never know what to expect that day. Exercising dominion over other people is a dangerous and stressful job. The job they do is equally dangerous to any other public safety officer and just as likely to have false allegations made against them. Convicted felons often make allegations for many different reasons. Some are legit and deserve the full weight of the law and protections that they deserve. Some complaints are made for nefarious reasons, like you're angry at an officer for enforcing the rules, or you feel like he's been exercising favoritism with other inmates. Any charge against a correctional officer carries with it serious consequences. The language in the legislation ensures that this procedure is not in effect for any criminal investigations. These correctional facilities are severely understaffed and overworked. Senator Hanger and myself conducted a one-year study of working conditions in our corrections facilities in Virginia, and we saw firsthand the heroic and often tough assignments that they're given, and it is they are much to be admired for the work that they do. Currently, during an investigative process, the officer has no right to representation and has limited due process. This legislation would give some of the Commonwealth's most valued employees who do some of the toughest, most dangerous jobs the protections they deserve. So here's what the legislation would do 8 things. Any questioning shall take place at a reasonable time and place, preferably when the correctional officer under investigation is on duty. The correctional officer can have a representative of choice present during such questioning only as an observer. The correctional officer shall be notified in writing of all charges. The correctional officer shall be given an opportunity to respond orally and in writing to the charges with help at his own expense. Whenever a correctional officer is dismissed, demoted, suspended, or transferred for punitive reasons, he may request a hearing. At the hearing, the correctional officer and the agency shall have the opportunity to present evidence, examine, and cross-examine witnesses. The correctional officer shall also be given the opportunity to be represented by counsel or a representative of choice at the hearing. The hearing shall be conducted by a panel consisting of 1 member from within the agency, selected by the grievant, 1 member from within the agency appointed by the agency head, and a 3rd member selected by the other 2 members. The legislation would not prohibit informal counseling of a correctional officer by a supervisor in reference to a minor infraction of policy or procedure that does not result in disciplinary action being taken against the correctional officer. We need to put these folks on the same par with other folks who do our public safety work. This is long overdue. It has gone through finance here previously 2 years ago and was found to not have any cost. It came through over in the House, and in appropriations subcommittee, they wanted to refer it to the Crime Commission for review, but the Crime Commission did not find it appropriate to do that, nor do I think they would study something like this. So I think it's time we move this on. Thank you, Mr. Chairman.
Thank you. Who just hollered? Senator Black.
And if I just ask the patrons, what you've laid out here is just fundamental due process, isn't it? I mean, it's almost, the basics of what's required under due process, notice, the opportunity to be heard, and just slightly more than that.
It is fairly straightforward in that regard. And I'm sure, that it conflicts to a certain extent with some of the things the department does now. Otherwise, we wouldn't need a bill. But it is fundamental. And, I just came back from Colorado. I spent 3 weeks out there in corrections facilities where officers make $45,000 a year. We start our folks at $31,000. It's tough to keep people. And caring about them and caring about them in their most difficult times is essential to keeping employees on the job.
Thank you. Senator Cosgrove.
Just very briefly, I actually have 2 facilities in my district, St. Bride's and Indian Creek. I was not aware that our correctional officers don't have this protection. Senator Marsden was kind enough to explain that to me, and so that being said, I would move to report the bill.
Okay, so it's been moved and seconded to report this bill. Does not need to go to finance. All those in favor vote aye.
Ayes 14, no zero.
Ayes
you, Mr.
14, no
Chairman.
zeros. Thanks, Senator Marsden. Okay, now we're up to committee member bills. I'm going to take Senator Serville's bill real quick. And Senator Serville, let me just remind you not to be lengthy, because what we're doing with this bill, I have all of Senator Favola's bills left, and she would like those heard, because next week is alcohol bills.
Got it. No, this will be very quick. This will be very, very quick. There's been a lot of, I don't know if anybody's looked at the bill yet, but there's been a lot of newspaper articles written about this bill really quick, and I'm going to make a
Committee will bring their attention to Senate Bill 93.
and I'm going to request that this bill be continued to next year, but just before doing that, the parole board chairman is here and would like to address the committee really fast because there's been a lot of attention on this. Back in 1985? 82. General Assembly passed the law which basically made people ineligible for parole if they were convicted of 3 offenses of robbery, rape, or murder. Unlike other 3 strikes statutes, though, this one does not have an at-liberty requirement in it. So, in other words, if somebody commits 3 robberies, say in like a week, and they can fall into the 3 strikes category. Whereas we usually, when we pass the other 3 strikes laws we have, you have to be out of jail between each conviction. There's about 260 people that are currentently in prison. This only affects people that were convicted between 1982 and 1995, and there's about 260 people which this has caught up. And many of these people are serving sentences longer than murder for pretty minor robbery offenses. And it's something that desperately needs to be fixed. It's very inequitable. The parole board has taken inconsistent interpretations of it through the years. A lot of these people did not know when they were convicted that this was going to happen to them. The parole board has recently changed their interpretation and is beginning to work through this population. And in light of that, I think we need to give them a year to sort of figure out where they are, who's there, what they've done, before we take any legislative action. But if you've read the newspaper articles about some of the people this has affected, I know Senator Black has actually represented a few of them. The results have been very inequitable and unfair. And I think Adrienne Bennett, who's the chairman of the parole board, is here, and she just wants to speak really quick before we do this.
Got a real quick question for you, Senator.
Yes, sir.
Mr. Chairman, if I may, what would happen, Senator Serville, if I shot 3 police officers and they all died?
Yeah.
Would I be eligible, and it all happened in a same or similar incident within the time that I wasn't caught and the time I was arrested? Would I be eligible for parole under the way this changes?
If you did it today?
No, if I would have done it back then.
If it was all as part of the same incident, then that wouldn't fall into this at all. The way the law works is that it has to be things that would have to be charged separately. So there would have to be like one officer gets shot and then a few days later another one gets shot and a few days later another one gets shot.
What if while I was escaping, something else happened, I shot the second one, and then I'm escaping from him, and so it would be 3 separate charges of murder. Then under this, would I be eligible for parole?
No, the way, I think it has to be the same, if I forget the magic language, but it has to be like the same transaction or there's a way certain crimes all get brought together when they're charged, and if it's like part of this, if there's a continuous series of facts or moments that ties all the crimes together, they can be brought as one offense. That wouldn't fall into this.
Okay, but on the other hand, if I robbed a liquor store today and shot somebody, and then robbed a liquor store tomorrow and shot somebody else, and then went in and a police officer was in a bank and I robbed the bank and I shot him and the security guard, 3 different incidences, how would I be eligible for parole under this today?
Today, no.
If we change this and it happened during your time frame, would I be eligible for parole?
If we pass this law, then yes.
At that point, I would be eligible for parole, no matter what I did back then.
Yes.
As long as it was 3 different days or 3 different completely separate incidences. Okay. Okay.
Yes.
That answered my question, but
Yes.
thank you very much.
Okay. Ma'am, step on up, please.
Yes, sir. Thank you. Thank you, Mr. Chairman.
I don't necessarily have anything to address directly with you all, but I'm here to answer any questions that you may have in terms of how we're handling this and historically or any other questions that you may have, Chairman.
Does anyone have any questions? Well, by the chirping, I don't think we have anything yet, but we'd be happy to keep in the rest of the committee for the year for Senator Servo to work with you, try to work through this. So if that's the motion,
So moved.
to pass it by in the year, keep it in the rest of the committee. It's been moved and seconded. All those in favor will vote aye. Those opposed, no. Okay, so that's been passed by for the year. Senator Hanger.
Thank you, Mr. Chairman. Members of the committee, I have Senate Bill 539, Child Care Exemption from Licensure. Mr. Chairman, members of the committee.
Senator Hanger, can I just interrupt you real quick?
Sure.
Ladies and gentlemen of this committee, you've heard Senator Hanger's multi-year child care bill. It came out of here 15-0 last year, off the floor 38-2. So this should be pretty quick. Senator Hanger, if you want to just wrap up what we're changing quickly on it.
Yes, I will. The substitute that you have in front of us doesn't differ from last year's bill, with the exception, last year there was concern from Virginia Parks Association. So I have a substitute. If we have, if you could distribute and adopt a substitute.
So I have a motion to adopt the substitute. It's been seconded. All those in favor say aye. Aye. Any opposed, say nay. All right, then properly before us.
Thank you, Mr. Chairman. The substitute adopts a specific provision under a section on page 7 where it makes clear that these local school division, or not school division, but local government run day programs, recreational programs that are appropriately staffed for school-age children are not required to be licensed. The essence of the bill essentially is it gives parents reliable information on all programs available, licensed and unlicensed. It sets minimum standards for safety and health for those operating as licensed exempt child day programs, because currently there are none. But this is an important point, no one is losing their exempt status. If they've previously been exempt, they will continue to be exempt. It's just that they are required to do certain things, notably making sure that they represent that to anyone who presents himself and wants to utilize their services. Mr. Chairman, I know you're short on time, so that's the bill. There's a lot to it, but last year it got caught up over in the House with a couple of the members over there wanted to accomplish some other purposes, really not related to what we were trying to do here.
I understand monkeying with bills. Anybody have any questions for Senator Hanger?
Second.
All right, we have a motion to report to substitute. All those in favor, you'll vote. Oh, and re-refer to finance, yes.
Did the staff request it? They did? Okay, shame on them.
You are the chairman.
We know the chairman.
That's good, that's fine.
Ayes 13, no 0.
Ayes 13, no zeros. Thank you, Senator Hanger. Okay, Senator Mason. Senator Mason, I think you have a substitute with that bill? All right. All right, we've got a motion to move the substitute. It's been seconded. All those in favor to move the substitute, say aye. Aye. Any opposed? All right, substitutes before the committee.
Thank you, Mr. Chairman. The substitute's my fault, drafting error, because I just drew it to the wrong section of the code. Whoops. The Community Services Board asked me to bring this bill. This burglary is a barrier crime, so therefore, if you are ever convicted of burglary, you cannot work in Community Services Board. My local Hampton Newport News Board has a gentleman that was convicted of burglary 25 years ago, and when he was addicted to heroin, it was in advance of his addiction. Today, he has been helping people who are addicted because the Community Services Board essentially saved his life. We were on the Courts of Justice Criminal Subcommittee up in Winchester a few years ago in the other body, and they suggested that 80% of their crime was tied to the drug trade. So this gentleman today works for the Department of Criminal Justice and the sheriff because he is unable to work for the Community Services Board. He's had his rights restored, and this is just giving him an opportunity to work with the CSBs to be a peer consultant and a peer specialist, to try to tell the story of how the CSB saved his life when he was addicted. And so this would allow, now one thing I would like to direct you to, and I don't know what line it's on the substitute, but this is just making someone eligible for screening. Okay, and let me read that to you. To be eligible for such screening, the applicant shall have completed all prison or jail terms, shall not be under probation or parole supervision, shall have no pending charges in any locality, shall have paid all fines, restitution, and court costs for any prior convictions, and shall have been free of parole or probation for at least 5 years of all convictions. So that is just to be eligible to be screened by the committee in advance of the opportunity to work with a local community service board or provider.
Pretty straightforward, Bill. Thank you for that explanation. Does anybody have a question for Senator Mason on the bill? I don't see any questions.
Move the report.
I have a motion to report. It's been seconded to pass Senate Bill 555 as a substitute. Okay, we have a substitute motion. Senator D-Staff?
I move we PBI this.
Okay, the motion is to PBI. Is there a second? It's been moved and seconded to pass by indefinitely this bill. All those in favor say aye. Opposed? Okay, so,
Aye 6, nay 7.
okay, so aye 6, nay 7, so the bill to report is in front of us. So if you choose to report the bill, vote aye. If you don't want the bill, vote no. Clerk, clear the board and let's revote.
Ayes 9, noes 4.
Ayes 9, no 4. The bill passes.
Thank you, Mr. Chair.
Okay, Senator Favola, you finally get your day.
Can you do your easy one first? Do your easy one first?
Okay, I'll try. And Mr. Chairman, I will start with Senate Bill 183, and this bill was the result of work by the Commission on Youth. And what it does simply is it would require the local department, this would be probably the Department of Child Support Services, to notify the Superintendent of Public Instruction without delay when an individual holding a license by the Board of Education is the subject of a founded complaint. So, again, we had an incident where we had an employee in the Arlington school system. A complaint was filed on a sexual assault or an assault case, child assault case, and the case went to Child Protective Services. It was evaluated, and there was a delay, surprisingly enough, in reporting the fact that there was a founded case, and this actually would correct that situation.
Okay.
In fact, the Superintendent of Instruction asked for this bill and said he would want to know. This was, again, this was a school employee. So it's very straightforward.
So if the committee will bring its attention to line 131 through 132, it strikes those words, what Senator Favola is so eloquently speaking to. So does anybody have a question for Senator Favola on 183? Senator Wexton?
Senator Favola, would this apply only after all the due process had run its course? So if there's a finding, a founded finding at the local level, but it's being appealed, would the report have to still be made or?
No, my understanding is, and I do have staff here to illuminate this if I don't give you enough information, that once the finding takes place, it's reported to the Superintendent of Public Instruction, and the appeal could still be in play. So the superintendent's just aware that there was a finding, but it doesn't, this says that the finding has to be relayed to the superintendent without delay, so there's not a wait period until the appeal process is completed. Is that your question?
Mr. Chairman, I
Go
guess
ahead,
just
Senator Wexton.
based on that, is the problem that it's not, that it's not being reported to the superintendent of public instruction at all, or that it's not being reported while while that investigation and finding are pending? You know, for example, if there's a lapse of time between when the local decision is made and when it goes down to the state
Senator
level.
Wexton, I think what's happening is people are appealing and keep kicking the can down the road, appeal after appeal after appeal. And if you read the bill that was been struck, it says been exhausted. Well, some people make that exhaustion go for 2 years. So I think what they're trying to do is make sure people are informed quickly.
Carl Ayers is here to answer
Come on
a
up,
question.
Carl.
Good morning, Mr. Chairman.
Good
Senator
morning.
Wexton, Carl Ayers, Child Welfare Director for Virginia. What this does is the local school board is notified when you have a founded complaint, but the superintendent of public instruction is not notified until after the administrative state appeals processes is occurring. So just as the chairman mentioned, in the specific case, this appeals process drug out for over 2 years. So the state was never notified until after 2 years. The individual is able to go to another state after sexually abusing a child and continue teaching. So the idea is to make sure that that notification occurs and that in these serious offenses that we do not allow these loopholes to where people that are offending on our children are able to continue doing that and being exposed to other children. That's the specifics of this bill.
Got it.
Of all three bills. Actually, he gave you the context for
Okay.
all three.
Anyone else have
This
a
is just-
question?
This is just picking away at
Senator
one or two.
Sorbo.
I have a question for the gentleman that just spoke.
Go ahead.
Sorry.
Yes, sir.
I understand there's this one case that seems to have generated a lot of bills that people are unhappy about. And I also know that often one case doesn't make the best law for the entire system. I'm just curious, how many of these types of founded complaints are overturned on appeal on an annual basis? What's the number of people that are going to have something sent out that says that they did something that later is reversed where it's later found they didn't?
8 cases.
8 a year?
8.
So there's further question? So would you agree then that there's roughly, say, 5 to 10 people a year, they're going to have something sent out that said they abused a child to the superintendent when later it turns out that there's not a founded complaint?
According to 2017 numbers, there were a total of 8. There were 30 founded cases. 8 of those were overturned on appeal. So 22 that were upheld,
Okay.
8 that were overturned.
Got it.
Okay. Anyone else have any questions on 183? All right. Committee works on motion.
Second.
All right, it's been moved and seconded to report Senate Bill 183. All those in favor vote aye, those opposed nay.
Ayes 8, noes 6.
Ayes 8, no 6, that bill passes. Senator Favola, you got about 5 minutes to get through some of your bills. So choose which one you want to get through.
Oh, okay, well, let's just, why don't we try Senate Bill 184?
Okay.
And
Senate will bring their attention to 184.
what this bill does is it would allow, if a report of child abuse and neglect is founded, during the time of the investigation or the conduct that led to the investigation, then the Commonwealth, the school division located within the Commonwealth shall notify the relevant school board about the founded complaint. What was going on is we had an employee who left the employment of the school system, and the way the code read is when the employee was no longer an employee of the school system, there was a loophole in the process about reporting information, and so language was added about at the time of the investigation or the conduct that led to the investigation. So that, again, this just closes that loophole.
Okay.
Allowing CPS to report to the school board if there's a finding, again, on an employee that may have left the employment but was employed at the time of the incident.
Senator Serville, you're still in my queue. Do you have a question? Okay, anybody else have a question for what this does? Seeing none. All right, again, committee works on.
Report.
All right, we have a motion to report the bill. It's been seconded. It's before the committee.
Ayes 9, no 5.
All right, ayes 9, noes 5. That bill reports.
Thank you, Mr. Chairman. I've got Senate Bill 203. And what this bill does, it's a reentry bill. So if you are philosophically in favor of programs that help individuals who unfortunately have made a bad choice or had been convicted of a felony offense. In this case, my bill deals with a felony offense or a possession of a controlled substance, a first-time felony offense or possession with intent to distribute marijuana. After the individual has completed any court-required obligations, it would allow this individual to be eligible for food stamps. And I said with the possession with intent to distribute because in the code, if you have more than a half an ounce of marijuana, up to 5 ounces, in fact, you're considered more than a half an ounce to be subject to the intent language, which I think is pretty small. So that seems to be a very large gap. I do have a bill in to change all that because you do have individuals not knowing any better who could have more than a half an ounce on their person. They'd be convicted of a felony under the intent to distribute.
Okay, Senator Favela, I'm going to cut you off because
I've asked that this
we have heard this bill before. It's a little bit more narrow.
Slightly different.
We know what the bill does. I know you have witnesses. Can you just state your name, stand up, tell us if you're for or against it, please?
Good morning, Mr. Chairman, members of the committee. Salam Bhatti from the Virginia Poverty Law Center. We strongly support this bill. Thank you.
Thank you.
Mr. Chairman, members of the committee, this is Kevin Maurer, Virginia Catholic Conference. We also support the bill. Thanks.
Thank you. Yes, ma'am.
Kim Bobo, Virginia Interfaith Center for Public Policy. We too support both of the bills around food stamps. Thank you.
Thank you very much. Any members have a question for what this bill's doing? It's pretty cut and dry. Okay, we have a motion to report the bill. It's been moved and seconded.
Second.
It's got to be re-referred to finance because there is an impact to this committee of vote.
Ayes 8, nays 6.
Okay, the bill passes 8-6.
Mr. Chairman, here's another bill that this committee has heard before. One slight amendment, and it's Senate Bill 204, and it has to do with, again, TANF eligibility after a drug-related felony. I would ask that the committee put a period. I just want to make sure I get this correct. Such person complies with or has already complied with all obligations imposed by the criminal court and the department and is actively engaged in or has completed a substance abuse treatment program. So on line 18 after program, put a period and strike everything else.
Okay, David, are you tracking on that?
Yep, Mr. Chair, there'd be two line amendments. One is on line 18 after department, strike the comma, insert an and the second is also on line 18 after program, strike the remainder of line 18, all of line 19 through 23, and through substances on line 24.
Okay. It's been moved and seconded that the amendments be taken. All those in favor say aye. Any opposed? Okay, bill's before us.
Well, Mr. Chairman, this bill restores eligibility for TANF assistance to first-time felons convicted of possession of a controlled substance. Again, to be eligible for TANF, you have to be an intact family. Most of the TANF recipients are single moms with 2 children. These are individuals who have already completed any court-required condition that they had to meet They will have completed a substance abuse treatment program. They are in our communities. This has nothing to do with the sentencing. They're in our communities. They're trying to get their families together, and they're trying to integrate back into the mainstream and support their families. We really need to do
I
this.
have questions. Senator Black,
Yes.
go ahead.
Mr. Chairman, just really a comment. I just have a great deal of trouble rewarding people for their drug felonies. And if they've got the money to where they can be out purchasing narcotics, then I don't see why we need to be providing them with taxpayer dollars.
Wouldn't you agree? Senator DeStaff. Go ahead.
There we go. I had a quick question. You said a majority of these are single moms with 2 children. What percentage of those were arrested under drug-related felonies are single moms with 2 children?
Well, if they were arrested for drug-related felonies, they're not receiving TANF, so I don't have that information. I just know what the TANF profile looks like, looking at the current recipients of TANF.
So the fact that you put out of, it's most of these are single moms with 2 children, I'm just trying to find out where you got that fact. Where that information came from. Can you cite it?
Mr. Chairman, Senator DeStaff, I'm just citing the profile. It came out from the Department of Social Services. There was a report 2 years ago, and they talked about the profile of the TANF family. And that's where I got it from. I don't have the report with me, but I
Okay.
read their reports every.
If you can give me a copy, Mr. Chairman, if you could provide me a copy of the report, I'd appreciate it. Thank you very much.
Yes,
Great.
I will ask the department to do that.
Okay, we're over time, so again, state your name and if you're for it or not.
Good morning, Mr. Chairman. Salam Bhatti, the Virginia Poverty Law Center. We're for it because the only criminals ineligible for public assistance are drug felons. You can murder somebody and still get public benefits, so we ask you to support this. Thank you.
Mr. Chairman, Kevin Maurer, Virginia Catholic Conference, we support.
Thank you.
Linda Higgins, Virginia Center for Public Policy, and we support.
Thank you, ma'am. All right, so I have a motion to report. It's been seconded before the committee to report the bill. Who has a question?
Finance.
It does have to go to finance. Yeah, I'm sorry. Better look at my notes. It's got to go to finance. So the motion is to report. Okay.
Ayes 8, nays 6.
Ayes 8, nays 6 to report to finance. It's going to finance. And with that, the committee will rise.
Thank you, Mr. Chairman.